On December 3, 2009, Kevin Tullson sought emergency treatment at St. Agnes Hospital's urgent care in Baltimore, Maryland, after an overhead gate fell directly onto his left knee. During triage, staff noted that he was unable to move his left foot. Physician assistant Michelle Krupa performed the initial examination, ordered knee x-rays, and administered IV pain medication before presenting the case to attending physician Dr. Prudence Jackson. Dr. Jackson conducted a bedside evaluation, agreed with the PA's assessment, signed the chart, and approved Mr. Tullson's discharge with prescriptions, crutches, and instructions for outpatient orthopedic follow-up. But just days later, Mr. Tullson returned to the hospital after developing a complete arterial occlusion in his left leg. Severe ischemic damage followed, ultimately requiring an above-the-knee amputation. He later filed a medical malpractice lawsuit in the Circuit Court for Baltimore City against St. Agnes Healthcare, Dr. Jackson, and associated care providers. The lawsuit alleged that the failure to properly evaluate, test, and diagnose the vascular injury fell below the accepted standard of care and contributed to the loss of his limb. On August 5, 2013, plaintiff's attorney Rodney Gaston deposed Dr. Jackson. Defense attorney Danielle Dinsmore represented Dr. Jackson, while attorneys Mary Pat McGuire and Robert Speltz Jr. represented Caroline Stell and St. Agnes Healthcare. And during this deposition, Dr. Jackson would be questioned about the decisions made during that critical emergency room visit and whether something important was missed.
Since you became licensed to practice medicine in the state of Maryland, have you also had the opportunity to supervise physicians' assistants in emergency room settings?
Yes.
Okay. So it looks like that you are aware of the standard of care that will be applicable to doctors such as yourself for practicing medicine in emergency room settings, and also aware of the standard of care that would be applied to physicians' assistants whom you supervise in an emergency room setting. Would that be a fair statement?
I'm just going to object to the form and foundation.
You can still answer.
Would I be aware of the standard of care? I don't know exactly what you mean by that. The standard of care is supervising them.
Okay.
Can you explain what you mean by that?
I'm glad you told me you don't understand the question. Let's go back a little bit forward. Let's go back just a little bit. What is your understanding of the definition of standard of care in the field of medicine?
Accepted practice.
Can you be a little more specific than that?
My interpretation of it would be the accepted practice for doing things across the medical field.
And is that definition applied to doctors as well as physician assistants?
I don't know if you can say, does it apply to doctors as well as physician assistants? The standard of care is a standard of care. It applies to those that work in the medical field. Which
would include a physician assistant that you supervise. Would that be a fair statement?
I'm just going to object to the form and foundation and the vague nature of the question.
Yeah, I'm not sure what you're getting at. What are you getting at, sir?
Well, let me ask the question in a different way. When you supervise physicians' assistants, are you aware, or do you have to be aware, of the accepted practices within the field of physician assistant medicine that they are required to follow and carry out?
No, I have to be aware of the standard of care and the practice of medicine in general. There's no separate standard of care for them.
Okay, but what I'm saying is, are you aware of the standard of care for physician's assistants?
What is this? I mean, you're trying to apply a separate standard. You're trying to apply something to them that. Are you asking me how they should be supervised? What exactly are you asking?
No, ma'am. Let me go back again. We've already established your definition of the standard of care for emergency room doctors such as yourself. You told me what that is.
No, what did I say? What did I say?
You said it's the accepted practices for the way that doctors do things in the field of medicine. Do you recall that?
Yes.
Okay. Now, what I'm trying to say is, because you supervise physicians' assistants, I would presume that you have to know the standard of care that applies to them for the manner in which they do things in a hospital setting. Would that be a fair statement?
I'm just going to object
I
to
don't
form
think
and
that's a fair.
I'm going to object to form and foundation, and I think what we're struggling with is you're not being specific enough.
Well,
Perhaps if you provide some more detail as to the.
in order, you do supervise physician's assistants, correct?
Yes.
Okay. And part of your supervisory duties, you have to evaluate the way in which they examine a patient, the way in which they run diagnosis, and the way in which they provide medical care and treatment. Would that be a fair statement?
Yes, we do look at those things.
Okay. Now, what I'm trying to figure out is, in order to do that properly as an emergency room physician such as yourself, do you have to be aware in the manner in which they are supposed to carry out their duties?
I would say that I should be aware of how things are to be done in the practice of medicine in order to supervise them. But there's no specific set of standards of care for them, which is what it sounds like what you're saying.
No, I'm not suggesting that there's a different standard of care, but what I'm suggesting is there's a standard of care for physicians that you've described. Do you believe it's the same standard of care that would apply to physician's assistants who you supervise?
Objection, form, and foundation.
I would say the standard of care applies to all medical providers that are practicing medicine, including physician assistants.
Okay, all right. Now, and over the course of your medical employment as a physician, can you tell me how many physician's assistants you have supervised over the years?
Oh, I don't think I can give you a number, but there have been quite a few.
More than 10?
Yeah.
Probably more than 20?
Perhaps, yeah.
Okay. And with your employment, while you were working at St. Agnes Hospital, can you tell me what the shift work was like? What shift you worked? Were you the only doctor there? Were there other doctors there? How many nurses were there? How many physician's assistants were there?
And working at St. Agnes in the urgent care department, I did various shifts. We had an evening shift and a morning shift in the urgent care. There's usually one physician, and there's usually one physician assistant. There may be one or two nurses.
Mr. Gaston then questions Dr. Jackson about her role in supervising physician assistants and how she evaluates their handling of patient cases, including their physical examinations, diagnostic findings, and treatment plans. Under Maryland law, a supervising physician has a duty to establish a review process and maintain ongoing oversight of a physician assistant's patient care. That includes ensuring that the assistant's examination findings, diagnostic reasoning, and treatment decisions meet accepted medical standards. Gaston appears to be building an argument that Dr. Jackson may not have provided adequate supervision, or that the heavy patient volume at St. Agnes Urgent Care may have affected her ability to properly fulfill that responsibility. He also focuses on whether Dr. Jackson applies the same medical standards when reviewing physician assistants as she would when evaluating her own work. The questioning is designed to establish Dr. Jackson's exact supervisory responsibilities and determine whether she could be held indirectly responsible for the care provided by the physician assistant.
Do you agree that the medical care and treatment he received in this case after you treated him, which would be the follow-up care at St. Agnes Hospital, and then the care at University of Maryland Hospital, which would include the amputation of his leg, was fair and reasonable medical treatment?
Objection. I'm not going to permit Dr. Jackson to respond to that question. She's not being offered as an expert witness on the topics that you just asked about. She's here as a fact witness to talk about her care and treatment of Mr. Tullson on December 3rd, 2009.
Well,
An objection on behalf of St. Agnes Hospital as well.
And I also add that she has testified that she scanned the chart from St. Agnes following December 3rd and that she has not looked at his medical records from the University. So there's no foundation for her to respond to that question.
Well, you do understand that he had to have his leg amputated, correct?
That's what I was told.
Okay. And during your deposition, I'm allowed to ask you whether you admit or deny certain facts in this case. And I'm also permitted to ask what you claim in this case as a defense. And the reason I'm going over this is that when we get down to trial, the plaintiff has the burden to prove that the medical care and treatment he received was fair and reasonable. And that's why I'm asking you this. If you admit that, I'm going to ask the question again. If your lawyer wants to instruct you not to answer the question, she could do so, but I simply want the record here that I'm trying to obtain an admission from a defendant in a case on medical care and treatment, which would then alleviate my burden of proving that issue at trial. So I'll ask you again, do you admit that the medical care and treatment Mr. Tullson received after he was seen by you, which would include the medical care at St. Agnes Hospital and the medical care at University of Maryland Hospital, which ultimately resulted in the amputation of his left leg, was fair and reasonable medical treatment?
I'm going to continue with the same objections as previously stated and add, based on your restating the question, that your question calls for attorney-client privilege and attorney work product, and we do not admit that Mr. Tullson's medical care following December 3rd, 2009 was fair and reasonable, and that's your burden to prove, and that's what you need to do.
Okay.
Objection by St. Agnes as well.
Doctor, what facts are you aware of to support your claim, if there is a claim, that his medical care and treatment after you saw him, which would be St. Agnes Hospital and University of Maryland Hospital, was not fair, was not reasonable?
I'm
Objection.
going to object, and I'm going to instruct the witness not to answer because, again, it calls for attorney-client privilege and attorney work product. And the claim that was made on the record was by counsel, not by Dr. Jackson.
Doctor, item number 2, we ask you to produce for any documents, photographs, videotape slides that you have or have reviewed for this case. Do you have any of those items?
No.
Okay. We also ask you to produce documents, medical treatises, textbooks, other articles reviewed by you in preparation for your deposition. Do you have any of those?
No.
Have you reviewed any of those items?
No.
Okay. Do you intend to rely upon any medical textbooks, treatises, or articles in this case?
None in particular.
Do you intend to give any opinions in this case?
Dr. Jackson's not going to be offered as an expert witness to testify on the standard of care on anyone else other than the care and treatment that she personally rendered to Mr. Tullson.
Okay. I still need to know if you intend to give any opinions on the witness stand.
I just told you what she's going to offer opinions about.
I'm sorry, I thought you said she's not going to give opinions on standard of care.
Exactly. She has no
Okay.
opinions relative to standard of care on anyone other than depending on how questions are asked at trial or in this deposition, she may offer opinions as to her own care and treatment of Mr. Tullson.
And I need to know what opinions you intend to offer on your own care and treatment of Mr. Tullson.
Check the Foreman Foundation and the general nature of the question you can answer.
So you want to know what opinions I want to offer on my care of him?
Yes, ma'am, because those are the only opinions that your lawyer said that you intend to give. So the reason I'm here, I need to know all of those opinions. And the second part of that would be I need to know all of the factual basis for those opinions. And we can go down one by one, and I'll go slow with you, and I'll give you as much time as you need to answer that question.
And I'm going to object to the Foreman Foundation and the fact that it calls for a narrative. Dr. Jackson may testify as to her care and treatment of Mr. Tullson and offer opinions depending on what she's asked at trial. That you can, if you can answer the question.
Okay. I believe Mr. Tullson had appropriate care during the time that I took care of him at St. Agnes.
Okay. And can you tell me the basis for that opinion, that he received the appropriate care?
Objection to form and foundation. Go ahead.
He was evaluated properly and he was treated correctly based on the findings I had at that time.
Dr. Jackson testified that she believed Mr. Tullson received appropriate care during the time he was under her direct treatment at St. Agnes Hospital. Her testimony focused on her role as the treating physician and fact witness. Under Maryland law, a physician is generally held to the standard of care expected from a reasonably competent healthcare provider in the same specialty and under similar circumstances. When Mr. Gaston asked whether Mr. Tullson's broader medical treatment across different hospitals was fair and reasonable, defense attorney Ms. Dinsmore immediately objected. She argued that Dr. Jackson had not been designated as an expert witness and therefore should not be asked to provide expert opinions about treatment provided by outside medical facilities. Dinsmore also asserted attorney-client privilege and work product protections, instructing Dr. Jackson not to answer questions that sought confidential legal strategies or defense positions. As a result, Dinsmore refused to allow Dr. Jackson to characterize the patient's overall medical care as fair and reasonable. This prevented the plaintiff from obtaining a direct admission on the issue and left the burden on the plaintiff to independently establish the necessity and reasonableness of the claimed damages at trial.
Who makes the decision as to what forms to use in the emergency room, what forms to fill out for the patient's evaluation?
Objection to form foundation. I'm not sure I understand the question even.
Doctor, do you understand my question?
I don't know the answer to your question, so who decides what forms are used? It would be, I could only speculate, it would be the administration.
If you're only speculating, then
Okay,
don't
I'm not going to
speculate.
speculate, but I don't know.
You're required to supervise physician's assistant Cooper, correct?
Yeah, I'm not required to make the forms and
Okay.
decide which forms are done.
Part of your supervision, would you agree, is to make sure she uses the right forms, to go through the checklist for the analysis of the patient?
Objection to form and foundation.
That doesn't make any sense to me.
Don't make any sense to you?
You know why? Because I'm responsible for clinical care of the patients and the clinical aspects, not for the forms and the paperwork and stuff. Yes, she has to fill out a medical record sheet, yes.
Right, because as all physician's assistants who take over the care of a patient, they're required to accurately chart the examination they perform and the findings. Would you agree with that?
Objection to
object.
form.
I'm also going to object because I think now your questions call for expert testimony. She's not here as an expert to comment on the reasonableness of Ms. Shaw's care and treatment or documentation in this case as an expert witness. So if you rephrase your question, it might be permissible. Don't answer that question as phrased.
Ma'am, can you tell us if there are any continuous supervision mechanisms that you follow when you supervise a physician assistant at St. Agnes Hospital?
Objection.
Form and foundation. Do you understand the
I don't really understand what you mean by continuous supervision.
Mechanisms? You don't understand that concept?
I don't understand what you're saying now.
Okay, all right. Now, how do you evaluate the physician's assistant's performance in the emergency room at St. Agnes Hospital? How do you know whether or not they're implementing the right procedures, doing the right testing for the patient in order to meet the patient's needs?
objection to form and foundation?
We're right there with them. I mean, we're in the emergency room with them.
Well, you weren't with Ms. Krupa when she first examined Mr. Tullson, correct?
Oh, see, you're being...
Is that true or not? Were you with her when she did her initial examination?
I was in the urgent care department working with her, yes.
Were you in the room when she performed the physical examination?
I don't have to be in the room with her.
Just don't argue it. You got to wait till I ask the question, then you can answer it. Were you in the room with her when she physically examined Mr. Tullson?
I don't think so.
Okay, now, then how do you know, if you weren't in the room with her, that she performed all of the necessary tests for Mr. Tullson in light of his condition?
When I go in to examine the patient, I make sure that Everything that needs to be done for that patient is done. If there's something that I think that the PA has not done, then I bring that up for them to do.
Okay.
I check it because I check it myself as to what was done. And I don't really know what you're getting at there with that question.
What I'm getting at is, if you weren't there when she examined Mr. Tullson and didn't look at the chart to see what notation she made of the physical examination, then how did you know that she did the right examination of Mr. Tullson?
Because I examined it myself.
Okay, so it's solely based upon your examination. Is that correct?
Objection.
I don't know what you mean by that.
You don't understand my
I
question?
don't understand what you're getting at with that.
Okay.
It's solely based on, I mean, I'm telling you, I examined the patient myself.
Right, I know you did the
Krupa discussed the patient with me.
Right there.
I know you examined the patient yourself, but
Krupa discussed the patient with me. She discussed her findings with me. We discussed the patient and what was going on with the patient.
What-
Okay? It's not like she went off in a corner and examined the patient in private and I didn't know what she was doing.
what did she tell you about her findings?
She told me that the gentleman had an injury to his knee. Something hit his knee. She was getting x-rays. She examined him. His neurovascular status was intact.
Did you ask her what test she used to determine that his neurovascular status was intact? Or did you just take it at her word?
You know, I didn't ask her every test that she did on him because I went right behind her and did the testing myself. If she, you know, she tells me that she did a test on a patient and I checked behind her, I'm not going to question as to, you know, what every single test that she did to the patient. She's already reported that off to me.
After confirming that she personally examined Mr. Tullson following Ms. Krupa's initial assessment, Dr. Jackson testified that Krupa had examined the patient, ordered x-rays, and determined that his neurovascular status appeared intact. Under Maryland medical malpractice standards, a healthcare provider may be held responsible when the care provided falls below the degree of skill, judgment, and attention expected from a reasonably competent provider under similar circumstances. The questioning then turned to the responsibilities of supervising physicians. Maryland law places ongoing oversight duties on physicians supervising mid-level practitioners, potentially creating liability when delegated care or supervision falls below accepted medical standards. Mr. Gaston appeared to use Dr. Jackson's own testimony to support an argument of negligent supervision. He focused on the fact that Dr. Jackson was not physically present during Krupa's initial evaluation and had not reviewed the written chart notes before the patient was assessed. The goal was clear: establish whether Dr. Jackson's level of supervision was sufficient and whether something critical was missed before Mr. Tullson was discharged.
Doctor, if you can go to page 19 of the chart. And it's a square box. It says Emergency Department Management, Patient Record. The date is 12/3/09. The time, I think it's 16:04. It says page 1, where it says stated complaint 1 is leg trauma. It says priority 3, severity 9. Are you there, doctor?
This page here?
Yes, ma'am. 19.
That's not what
Oh, you have a different.
It's after that. I think that's it. Got it. Okay.
Thank you.
Can you tell me what the number 3 next to priority means?
Yeah, that's not paperwork that I fill out.
Can you tell me what the number 9 next to severity means?
I cannot.
Doctor, You indicated that one of the examinations you performed on Mr. Tullson was skin temperature? Is that
Yes.
correct? Okay. What was the temperature of his skin? Was it, how did you note that? Did you note what his temperature was, whether it was warm, cold, clammy, dry, cool in the chart?
I think I've told you that it was warm to the touch. It was not cool and clammy.
Did you make a note of that anywhere in the chart?
No, I didn't make a note of it myself, no.
Was there a place in the medical chart that you could have made a note as to whether his temperature was cold, warm, dry, anywhere in this chart?
Objection.
I mean, if I were seeing this patient myself, you know, I would have notated that, but I suppose there's a place you can put it anywhere if you want.
And if Ms. Krupa had done the same examination of you, because she was seeing the patient, would she be required to make a notation of the color, the temperature of the patient's skin in the chart?
Again, I'm not going to have her testify as an expert witness on the standard of care of a PA. So to the extent your question asks what is required of her, I'm going to tell her not to answer that question. If you rephrase it, maybe it'll work.
Well, hold on, doctor. You are required to supervise the physician's assistant in this case, particularly Ms. Krupa, correct?
When she is working in that setting with me, I am her supervisory physician at that time.
And part of that is you have to know what is required of her for the patients that she's treating, correct?
Objection. That states improper foundation. Go ahead.
Is that true?
I mean, it's too, in general, if you want to know in general, then what's required is to take care of the patient. That we make sure that the patient is taken care of appropriately, and that's what was done.
But what I'm asking for is what is required in this case for Mr. Tullson.
In terms of filling out forms?
No. What I'm asking for is you are certainly aware of what was required of her for the care of Mr. Tullson in this case, correct?
I'm required what's appropriate for care of any patient that comes in. And Mr. Tullson was taken care of adequately.
Okay, now, as part of that, does it require Ms. Krupa to note the temperature of Mr. Tullson's skin if she actually felt his skin? Was she required to write that in the chart?
I'm going to object because you haven't laid a foundation that her supervisory responsibilities include knowledge of what a PA is required to fill out at St. Agnes or under the standard of care.
Are you going to tell her not to answer the question?
Yeah, because you haven't
Okay.
laid a proper foundation that this is an appropriate question for a fact witness to answer.
Doctor, in this case, you examined Mr. Tullson, correct?
Yes, I did.
And you believed that what was required of you was to determine the temperature of his skin, which is why you felt it and concluded it was warm to the touch, correct?
Correct.
Would Ms. Krupa be required to do the same thing during her evaluation?
According to what Krupa reported to me, that is what she did.
And should that be written somewhere in the chart?
Objection. Again, it calls for her to render an opinion on what's required of a PA in terms of documentation.
Exactly, and this is the lady you're supervising. As far as your supervision of her, did you expect that she should have made that notification in the chart?
I would expect her to give me the correct presentation for the patient and treat the patient and not treat, the stuff that was written per se. We treated the patient, we looked at the patient, and her presentation to me included those things.
You didn't answer my question. My question was, in this case, did you expect her to make that notation regarding the temperature of Mr. Tullson's skin somewhere in the chart?
Objection. You can answer that question.
The only thing I expect her to do is present the patient appropriately and let me know that proper care was done with the patient. Once that presentation is done and I evaluate the patient and we agree with each other, then that is what matters for the proper care of that patient.
So is that a no?
I'm not saying no or yes.
Dr. Jackson refused to answer Mr. Gaston's questions about whether Ms. Krupa properly documented Mr. Tullson's skin temperature. Gaston focused on this detail because, during an extremity injury, skin temperature can provide an important indication of circulation and possible vascular damage. His questioning centered on whether the medical team followed appropriate emergency evaluation and documentation procedures. He was attempting to establish that the missing documentation reflected a broader failure to properly assess the condition of Mr. Tullson's injury leg. Dr. Jackson, however, maintained that real-world medical practice involves more than written chart entries, emphasizing the importance of direct patient evaluation and verbal communication. The case eventually reached a jury. On April 23, 2014, the jury found Ms. Krupa and Dr. Jackson liable for medical malpractice and awarded Kevin Tullson $5.2 million. On June 9, 2014, final judgment was entered, but the amount ultimately paid was reduced to $1.5 million because of a pretrial high-low agreement. The case highlights how critical thorough examination and accurate documentation can be in emergency medicine. Although Ms. Krupa performed the initial evaluation and Dr. Jackson signed off on the chart, the plaintiff argued that important signs of vascular injury were overlooked. The delayed diagnosis allowed severe ischemic damage to develop, ultimately resulting in the loss of Mr. Tullson's leg. For the plaintiff, the deposition became a crucial opportunity to examine the medical record, question the doctor's decisions, and demonstrate how the alleged failures in evaluation and supervision contributed to a devastating outcome. In the end, the jury's verdict delivered a major legal victory for Kevin Tullson, with the final recovery reaching $1.5 million. What do you think? Was this a failure of medical judgment, documentation, or both? Thanks for watching. If you enjoyed this courtroom case, make sure to like, subscribe, and turn on notifications for more real courtroom encounters, legal arguments, and trial moments. Courtroom Zentro, real court cases, legal analysis, trial highlights. See you in the next courtroom.